In other tribal affairs, the U.S. Supreme Court has heard arguments in a lawsuit that could change the way Native American foster children are cared for and who has the final say in where they are placed. Kennedy Sepulvedo has our report.
Holland versus Brackeen and the consolidated cases. Mr. McGill.
On November 9th, the U.S. Supreme Court heard oral arguments for Holland versus Brackeen, which challenges the Indian Child Welfare Act, or ICWA, as unconstitutional.
If you think about states and child welfare cases, states have almost unilateral authority when it comes to child custody cases involving state residents in state courts. ICWA gives tribes a role in those cases in the same way that states have a role in those cases. It requires a tribe to be notified when an Indian child is in a state court custody proceeding. It also allows a tribe, absent good cause to the contrary, to transfer those cases to tribal court, with the idea being that the best government to make decisions about what's best for Indian children is that child's tribe.
Congress passed the Indian Child Welfare Act in 1978 to end the removal of indigenous children from their homes and communities.
Somewhere between 25 and 35% of all Indian children had been removed from their families, and we're deliberately placing them in non-native environments, in non-native institutions, and with non-native families.
Congress really studied and spent years trying to kind of tailor a solution to how ICWA would promote tribal self-governance and tribal sovereignty, and how ICWA would also fall into the best interests or be part of the best interests of both tribal communities and Indian children as well.
ICWA provides preferences for the placement of an Indian child if the child must be removed from their home. The law states an indigenous child should first be placed with extended family. If that scenario isn't possible, the next solution is with a tribal member of the same tribe. And if that still doesn't work, the last preference goes to another Indian family, no matter the tribe.
Any one of those preferences can be overcome by a showing of good cause, that there are specific reasons that this child might be better off in a specific other placement. But in the absence of a very specific showing, the preference is that the child belongs in one of those settings.
The lawsuit, which comes out of Texas, argues the 44-year-old law exceeds Congress's power, imposes unconstitutional race-based classifications, and violates states' rights. In the hearing, attorney Matthew McGill argued on behalf of the plaintiffs that Congress does not have, quote, power to regulate Indians everywhere, wherever they might be in the jurisdiction of the United States. Both Justice Amy Coney Barrett and Justice Neil Gorsuch countered that Supreme Court precedent gives Congress, quote, plenary, meaning absolute, power to regulate Indian affairs. The next argument by the plaintiffs claims the law is based on racial classifications that violates the Equal Protection Act.
The Constitution itself identifies Indians and Indian tribes as subjects for special legislation, right? It treats them in a way that the Constitution does not treat racial groups. It treats tribes as being similar to, not identical, but similar to U.S. states and foreign countries as political entities.
The scariest argument that's being made is this equal protection challenge. The Supreme Court for decades has said that laws that apply to individual Indians as tribal citizens or Indian tribes as a whole are not based on race, because they're based on the tribe's political relationship with the federal government and the individual members' relationship with their tribe. If the court were to find that the law was based on race instead of political status, then the state laws would be subject to challenge, probably under state constitutions as well.
This is because Oklahoma has its own version of ICWA. Lastly, plaintiffs are questioning if ICWA violates the 10th Amendment's anti-commandeering doctrine, which prohibits the federal government from forcing states to adopt or enforce federal law. The defendants, which include the Biden administration and varying tribal nations, counter the argument with the precedent that Native American children have long been the concern of the tribes and the federal government. Justice Gorsuch acknowledged that if the plaintiff's theory is correct, the Supreme Court will be busy for the next several years reviewing other Indian laws. Now, that Supreme Court decision can be made anywhere between now and June of 2023. In Tahlequah, Kennedy Sepulveda, the Oklahoma News Report.